So hopefully you can hear me. If anybody's out there, please say hi. Just let me know if you can hear me. That's been an issue in the past. I'm running about 7 minutes late, so let's jump into the material. And so that is interesting. It looks like it didn't upload my whole presentation. Anyway, let's start with, I'm Virginia Spencer, and this is the fourth in this series. Today we're going to be covering mediation, state complaints, and due process complaints. So the learning objectives are just that you know how to explain your parent rights that are in the Notice of Procedural Safeguards, that you understand the verbiage, and that you can use this information in an ARD meeting, or at least you know enough about it going into an ARD meeting that you can negotiate for better services and avoid dispute. So what we're going to cover today is mediation. And mediation is a voluntary process. It's the only one that is voluntary. So it's the most informal of the three that we're covering today. The school has to agree to it, and you have to agree to it, and sometimes they offer it to you. Special education complaints, on the other hand, once those are sent in, they have to be investigated, and that process is finalized in 60 days. And then due process complaints are like filing a lawsuit, filing for trial, and those go in, and the only way you can stop a due process complaint is to file a motion to dismiss it. Otherwise, it's going to play out and you're going to go to hearing. Hopefully, we're going to get into how you can avoid going to hearing, and TEA does encourage school districts to mediate when there's a due process filed. So does this all sound like fun? I hope so. We're going to try and make it fun. If you ask me any questions, I can address those. So let's get right into mediation. There are some facts to know about mediation. The first one is mediation is voluntary. As I just said, a school doesn't have to agree to do it. You don't have to agree to go to mediation. It can be done without a due process being filed. So that may seem strange if you've never been to due process, but you can actually request one without having done any other kinds of complaints. But it's usually recommended as part of the due process continuum. And it can also be used for disputes other than IDEA Part B. So currently I have a student who has been in a grievance hearing, and the school offered to mediate as part of the grievance. So that is not under IDEA. It's local grievance procedures through a school district, but they decided to offer a mediation. So with mediation, the state agency pays for it. Now, when they say they pay for it, what they mean is they pay for the mediator, and that whole process is free because the mediator is being contracted by them. They don't pay for your representation, and they don't pay for the school's representation. So those are separate items. However, most school districts do unofficially reimburse attorneys' fees at mediation. A lot of school districts reimburse advocate fees at mediation. Some refuse to do so, but there's no law that prevents them from reimbursing an advocate. So mediators are often attorneys under contract with TEA. They're not employed by them directly. And a lot of mediators in Texas have been hearing officers, and they usually say, well, we didn't really judge, so we really want to get into mediating and hopefully being part of the process that ends in the school and yourself finding some mutual ground. So in that respect, they're impartial. And we'll get into what a mediation actually feels and looks like. But one good thing to know is if you hear that a mediator is good, or your attorney or advocate recommends a certain person because they have a high rate of success at settling disputes, facilitating that settlement, then you can actually choose a mediator. So you can propose to the school, hey, can we choose this person or that person? And they are going to give you an answer. And they a lot of the time they agree. One of the issues you can run into is that person's so popular, they're not immediately available. So you may have to wait. So you have to weigh up, you have to weigh those factors up, especially it depends on the situation for your children or your child. So the process is confidential. Mediations are not open to the public like hearings can be. They're everything in there. You sign usually sign a confidentiality agreement with the mediator. So the mediator sends you something beforehand saying you understand and agree to keep everything that's discussed confidential. Those people also have to be completely impartial. So in practice or in theory, they're not allowed to take sides and say, well, the school says XYZ, so your child has to be a bad kid. You're not going to hear those kinds of statements. They might come back and say, well, this is the school's position. What do you want me to take back to the school? So let's talk a little bit about what a mediation is like. Lately, they have been virtual. I haven't heard of anyone being in a face-to-face mediation lately. So usually the school has their people in one breakout room on Zoom, and you're with your people in the other room. So you can take who you want to mediation. You just have to inform the mediator that you're taking certain people. And you can take a representative. So you can take an attorney, you can take an advocate. And those people do not have to be approved up front like they do in, they don't have to be approved up front like they do for due process. And we'll get into that with due process. So it is bad form to show up on the day with someone and not inform the school that you're bringing them. One of the things that you're told ahead of time is that the agreements are enforceable in a court of law. They're like a contract. If you get to that point, if you do end up writing a disagreement with the school district that you both agree to, discussions can't be used in hearings. As I just said, they're completely confidential. It doesn't mean that the same issues can't come up in hearing. You just can't use anything that you heard from the school district as evidence. They're revocable up to 3 days, like a contract. So you can change your mind and revoke your agreement. And so what they really feel like is being in a meeting with a party that you can't necessarily hear or see. You might meet them in the beginning. Let's say you start at 10 o'clock and you have the day blocked off for the mediation, you might meet them at the beginning, but then they'll be in a breakout room and the mediator will toggle back and forth with you. And there can be opportunities for your attorney or advocate to talk with their representative directly. And those are called sidebars. And usually I prepare people by saying that it's almost like a Turkish bazaar. You're going to propose a solution knowing that may not be your bottom line. So before you go to the mediation, you really need to decide what is absolutely unacceptable to me and what can I live with, because the chances that you'll get everything that you want are very slim. And the school has to feel like it's getting something to be able to settle. So you kind of have to think about the psychology of the negotiation. Mediations can be very emotional. They can last for 12 hours. They really are a marathon, but that they are definitely the most informal or least adversarial way of resolving a dispute. So if you do get to the agreement point, it'll be like a contract and you'll have to sign it and the school representative will have to sign it. And usually these agreements go back and forth a few times. They get redlined, which means you might not like some of the language. Sometimes schools' attorneys will put gag orders in there. They look like gag orders. They don't want you to talk about having been to mediation publicly, which is a very hard thing because usually the cat's out of the bag. You've told people we're hoping to mediate. We're going to a mediation. And so usually those things get redlined because there's no parameters for them trying to hold you accountable if people find out about the mediation. Now, the contents of that settlement is another story because, of course, they could take you to court if that gets out. But again, that's a really gray area because I've had clients that have received mediation settlements through a public information request. And one of my clients sent me one of mine. It had my name on it. It didn't have the name of the student, but it had the school and it had the compensatory education that wasn't redacted. So they say it's confidential and you should take that seriously. But if those terms are ridiculous, like if we hear anybody that ever talks about your child you having gone to mediation, those are things that probably your representative may have an opinion on. So usually in these agreements, you have to release claims. And what that means is that you agree not to bring more claims based on the reason that you're at mediation. So you're releasing any claims that happened up to the point of signing. That doesn't mean you can't file or request a mediation in the future because the clock starts ticking again. So if you have a problem in a year's time, you can go back to mediation and you have that year look back. So usually in those mediation agreements, they'll ask you for what's called a full release. And that means that they want you to let go of everything, including things that may not fall under IDEA, like access, discrimination, bullying, things that fall under 504, the anti-discrimination law. So that's one thing to watch out for. So what could you use this information for? And it seems like an odd thing to bring up in an odd meeting, but sometimes when you know about these options for your child, when you go into that meeting, it may influence the way you talk to the ARD committee. So one of the big questions I usually get is why I really don't want to go to mediation because it will hurt my relationship with the art committee. And I found that that's usually not true, because the art committee are not in the mediation. The people that are in the mediation are usually the principal, the school's attorney, someone else from administration, like the assistant superintendent or the head of special education, but it's not people that work directly with your child. So when those settlements are drawn up and signed, the art committee is aware of them, but that's all they know. So that's what I like about mediation as an option, because it doesn't directly impact the art committee. So when you go in, you can have this in the back of your mind. And if you've got a particularly adversarial group of teachers and administrators, you can think, well, I don't really need to go down this rabbit hole, or I don't need to keep arguing about this point, because if I file for a mediation and they agree to it, then we can resolve it there without these people in the room. But these are things that should be shared in parent groups. If you're a member of a parent group, if you're on Facebook, it's good to know what a mediation actually feels like. And they are nerve-wracking. But if you have a good mediator, you can often get a lot of work done. And even if you don't reach a settlement on the day, what you can do is you can say, I'd really like to keep this line of communication open. The mediator might keep the docket number open. So there's a docket number for a mediation. And they may say, well, I want to let you guys keep talking for another couple of weeks, and let's see if we can get an agreement executed. So let's move on to special education complaints. So this process is a little bit more formal. And this is what most people think of when they think about complaining about schools. There's a model form on TEA's website, and it lays out all of the elements that need to be covered. So name of the school district, name of your child, where you live, what the claim is, where is it in special education, is it child find, is it not implementing an IEP, what exactly is the claim? And with complaints, you have a 1-year statute of limitations, so you have to make sure that you're not going back further than a year. So today's the 13th, you can't go back further than June 13th of 2021. So these complaints are very simple to file. Usually what I do is I take the criteria and the elements and I put them into a letter format, because that way you don't have any restrictions on using the form or filling the form out and hitting a word limit. You can pretty much just have free reign over the content. So that model form is really useful for guidance, or you can use it. When you write the complaint, it has to go to the school district as well. You can't just file it with TEA. I usually send them to the superintendent. So you would copy the superintendent on that submission. You need to include all your facts, although you can add more facts when TEA get in touch with you when they're looking at investigating. They get in touch with you and give you an opportunity to add more facts. But this is where parents need to they need to think about how they are organizing their facts. So if you're looking at the development of an IEP, that could be one set of facts. But if you're looking at their response over time, you might want to take all of your email communications and put them in chronological order so you can show TEA, look, I've talked to them about this 7 times over the last year, and they just haven't done anything. So it's very important to have everything ready. And I've told people, give them the kitchen sink. Don't leave anything out. If you're not sure about, if you don't have an advocate or an attorney and you're not sure about what's relevant, send them everything. Send them the proverbial kitchen sink. One thing that parents don't think about a lot, and you might want to think about, what kind of proposed resolution do you want? Are you looking at more minutes? Are you looking at training? What exactly do you think would set this situation right? And that can be tough, but TEA can order compensatory education, which costs money. So they can do things that will cost the school district money. They can also say, this is a pretty complicated situation. Why don't we schedule a mediation? So you can get a mediation as part of a complaint. And I don't think parents ask for that very much, because I have a client and we did a mediation as to resolve a complaint. And the TEA representative was kind of surprised. And we said, well, it is one of the things that you can do under the procedural safeguards. So it's actually in your notice of procedural safeguards, if you look at the document, as one thing that can be done. So they have 60 days to investigate and come up with a written decision. What people don't know is that the people that review the documentation are not necessarily lawyers. They might be people that work for school districts. They might be former educators, but they're usually not attorneys. So that's something to bear in mind before you send it in, as to which method you want to complain by. I've seen some pretty odd things in decisions, such as when a school said they did something and they wrote it down, TEA said that was a finding of fact, but there was no evidence. The school district just stated something and they took that at face value. So those types of decisions can be a problem for you. So I would think carefully about whether you want to do a state complaint or choose a different option. So like I said, resolution can be pretty creative. You decide what you want to ask for. It could be monetary, services, or training. I've seen TEA order a school to train their staff, any of the staff that work with the child in child find procedures. And the case was a mom had been asking for a special education evaluation, and they kept stalling and saying, well, you're not asking for it properly, or you didn't put it on the proper form. There's nothing in IDEA that says you have to use a form. They're optional. And so in that case, the corrective action was compensatory services, an acceleration of the evaluation timeline, and also training for all the staff that had been in contact with this child and the parent. So those are some of the things that you can get in an ideal decision. When TEA makes that decision, there's no appeal process. So you can't argue with them. You can't appeal to federal court like you can with a due process complaint. It's a final decision. So how can you use this information? Could you use this information in an odd or in some other situation? Well, definitely you can weigh this up when you're thinking about dispute. You probably wouldn't bring it up with an odd committee. So Priscilla, you've asked, can TEA order a school district to pay money reimbursement for private services. They certainly can. Like I said, you can use mediation to go or suggest it or propose it to resolve issues. As far as the complaints, I'd have to go through recent complaint decisions. I've seen them order compensatory services, and the unfortunate thing about that is they're ordering the school to do it. So the school's going to want to use their own people or whoever they contract with. So if this is somebody that you are employing, that's going to be tricky. So in that case, I would say I want a mediation, because at mediation you can definitely get that, and that's very common if you can justify it. Future services, that's your compensatory education. Again, TA might order the school to provide that. If you don't want the school to provide it, then I would, again, ask for mediation, and then you can cost that out. And we'll get into that when I cover when I get to due process, because those are things that if you've asked for as part of your resolution, then they have to consider them. So I actually, in the client that shall remain anonymous, where we went to mediation, we did get that. And sometimes school districts will just cut you a check and say, you can use this check as long as you send us the receipts and we see that it's someone who's qualified and meets our criteria, and usually that just means same qualifications, then that's fine with us. The other thing about these settlements, if you do get money or you do get compensatory services, those are not taxable. There's a treasury letter. I have it. I can send it to people if they want it. But anything that you receive for education is tax exempt with the IRS, and that hasn't changed. So the other thing to know about special education complaints is, if you're making the same allegations and you also have a due process on the same issues, TEA will put the special education complaint on ice. So they will just stop and wait for the hearing to play out and then pick it up if those things haven't been resolved. Now, if a hearing officer says, there are no issues here, I find for the school district, then the chances of TEA actually picking it up are slim to none. You're more likely to go to appeal court if that happens. So I tell clients, don't ever do that. If you want to file a TEA complaint to put pressure on them while you're in due process, that's a good strategy. But you're going to have to use an issue that isn't in your due process. So you find something different. So as before, if you do file on a separate issue and you're in due process, then they'll use that 60-day timeline again. So let's go to due process complaints and talk about those. So currently, the look back is 1 year. In September, that is going to go to 2 years. So that's going to be pretty interesting because people are, they're going to have a lot bigger look back. And so, claims are going to be a lot larger. They're going to be a lot more substantial. In Texas, the parent has the burden of proof. In some other states, when you file for a due process, the school district has the burden of proof. And how that works in Texas is you have to come up with a preponderance of evidence. And typically that means that your position is more than 50% likely. Now, we know in Texas that parents don't win due process complaints. And the rate right now is 5%. So the key thing is, why would you go to due process? Why would you file a complaint? Well, usually due process complaints are used by attorneys currently to force a school to offer a mediation. So it's all about that mediation again, because that's an opportunity to avoid litigation. I put exhaustion on here as well. Exhaustion means that you can't sue a school district, you can't go to court until you've been all the way through this process. So you can't go straight to court on IDEA claims. You can go to court on 504 claims, which, like I mentioned before, are those are federal claims, because there isn't a state implementing regulation for 504. And that covers access, discrimination, bullying, anything that prevents a child from learning or prevents access to an education. Those can go straight to federal court. So there is a model form for due process complaints as well. That model form is very limited. I usually recommend, again, writing it out or attaching details to the form, because the form is really simple, and you can put in the areas, see attached document, and attach a letter, which gives more detail. It's similar to a state complaint in that you're going to state facts or violations. So let's say your child has autism. You got an IEE that says he has autism and he meets the educational definition of AU under the federal law, but the school disagrees. So you would state that as a violation, a failure to identify, or child find if he doesn't have an IEP already. And you propose a resolution, and that's where your compensatory services, training, whatever you think is appropriate goes in there. And that goes in. And like mediation, they assign a docket number to it. It goes to TEA and the school district. At the same time, you have to send both, usually to the superintendent. TEA assigns a hearing officer, and you start hearing from, you hear from TEA, and you also hear from the hearing officer. Now, the system's gotten kind of complicated because there's SOA, which is the State Office of Administrative Hearings, and they use e-file, which is an electronic system. So if you file motions or things that have to go to the hearing officer, you're going to have to go into the e-file system and set up an account. It's free, but you have to get used to it. There are certain hearing officers that aren't in SOA. They're independently contracted, and you have to communicate with them directly, and they have their own rules. So that's kind of tricky. So usually you hear from the hearing officer, you hear from the school district. They put in a notice of appearance for their attorney. If they're using an outside attorney, that person will put in a notice of appearance. If you're using an advocate, the advocate will need to file the non-attorney authorization form, which you fill out, authorizing that person to represent you. And then the hearing officer makes a decision as to whether that person meets criteria and education and adheres to voluntary code of ethics, and so on. So the school has 15 calendar days to challenge the filing. And what they can do is they can send in to the hearing officer a notice of insufficiency, which means that they're saying that there are flaws in your argument, you're not really, or you've missed somebody's name out. They'll do all kinds of things to slow this down and burden you with having to either pay your advocate or attorney to do more paperwork, or yourself if you're doing it by yourself. If the school hasn't already, they have to give a response to the filing, and that has to meet the prior written notice criteria, which I covered in an earlier webinar. And prior written notice has those 7 elements, why we disagreed, the rationale, what we considered, what we didn't consider, the reasons why, and so on and so forth. So that goes in from the school's attorney usually to you and the hearing officer. TEA provides a parent packet to you for free, low-cost legal services. So they give you quite a packet of information during this time to help you find an attorney. And they also give you a list of attorneys that are willing to do hearings and advocates that do hearings. And then the amendments piece of this that I've got sandwiched in the middle is, if you find a new claim and you add it, you file an amendment, a motion to amend, the hearing officer may grant that and add it into the existing due process complaint, but sometimes it will move the clock. So there are tight timelines for due process complaints. The resolution period's 30 days, and then the hearing period is 45. So the reason these are so long is because of all of the preparation. It takes at least 60 hours for someone to prepare for hearing. And I'll get into that on a later slide. But as soon as you file, what happens is your child goes into stay put. And stay put is another word for pendency. Some other states use the word pendency, but it basically freezes your child's educational placement. And I filed before for stay put just to stop a school district moving a child into an inappropriate placement. So while they're in that placement, you can go to an ARD meeting, and if you both agree on certain changes to the IEP, then those can change, but you both have to agree. The school can't do anything without your agreement. And that confuses a lot of our committees. I've had to bring that up. So that resolution period is the 30 days where you try and either go to mediation, you have a resolution meeting, which happens within 15 calendar days. They have to do a resolution meeting, and it's usually in the hearing officer's scheduling order. So you get a scheduling order from the hearing officer that lays out all of the timelines. So it's pretty obvious when things end and when periods end and when things are supposed to happen. So the resolution meeting is purely an opportunity for the school to resolve the issues. Hence, it's a resolution meeting. It's not for you to go in and argue your point. And some schools will use it to obtain information, try and figure out what the parent's strategy is so they can tell their lawyer. Because that's the other thing. If you don't bring a lawyer to a resolution meeting, they can't. So it's usually you and the special education director, maybe your advocate. So those meetings can be very short if they're not really seriously trying to address issues. They might try and throw you what I call a tiny bone. Like they might say, well, we'll give you $2,000 to go away and let's sign a resolution agreement. And so you can leave that meeting in disagreement and say, we're willing to keep talking. We'd really like to go to mediation. So that is how resolution meetings usually go. And, some attorneys recommend, I've heard, that you tell them it's an all or nothing situation. I want everything I've asked for. So as I mentioned, there's a 30-day resolution period plus the 45 days to have the hearing and get the decision written. Expedited hearings are also mentioned in the Notice of Procedural Safeguards, and those are usually for kids who there's a disciplinary element to the hearing, so it needs to be expedited. There are special factor hearings where the child's either a danger, the school considers them a danger to themselves or a danger to other people. And then the hearing officers are typically attorneys. And some of them do mediation as well, which is kind of interesting. I'm sorry, I've got allergies. I'll be right back. Wow, that's great timing. So hearing officers are attorneys, and they're impartial, which is a matter of contention for for people in the state, because there are so many decisions against parents that many attorneys think that they're really not impartial at all. So I have done a hearing as an advocate and got all the way. And there's a process. You have to, if you do decide to go to hearing, or you unfortunately can't settle, then you have to prepare like you're going to trial, and you have to line up witnesses. You have to make sure that the teachers and the school personnel that you want are available and you don't have to subpoena them. You have to provide a joint witness list, an exhibit list. You have to get all your exhibits organized, and you do have to send them to the opposing counsel. They have to send you theirs. You have to have a joint exhibits. And so you have to work with opposing counsel. If you're doing it pro se, you probably need to consult with someone at a minimum on this. And non-attorney representatives, as I mentioned, have to send in that form and be approved. Attorneys don't. So it really is like trial, except probably more like arbitration, because you don't have a jury. But the examination and the cross-examination, if you haven't attended an open hearing, is very similar to trial court. So there's a lot of going back and forth. And usually most hearings are 2 days, depending on the complexity, but you as a petitioner have an opportunity to put on your case, and then the school puts on their case. And it's usually in that order, but you do have an opportunity to cross-examine their witnesses. Hearings can be open, so you can invite people to listen. The decisions by the hearing officer afterwards, usually each side writes a closing brief saying why they should win, basically. And that goes in, and the hearing officer says, well, how long do you need to write your brief? and it might be a month, and then after the brief has gone in, the hearing officer will say, well, I'll get the decision within a week of having gotten the briefs. So that's pretty up in the air. I mean, the decisions do have to be made, but usually what happens is the timeline gets not muddled, but it gets extended, because if you have a mediation in the middle of this and the mediator's not available until a certain date and it conflicts with the scheduling order, the hearing officer will grant a motion for a continuance to push things out so there's an opportunity to reach an agreement at the mediation. So there are no extensions, however, for those expedited hearings. You can find the timelines in the Notice of Procedural Safeguards, but they're very short. So for the expedited hearings, they're about half the time of, so that's 75 days becomes 30 days. Very, very short timeline. So the implementation of the hearing officer's decision, let's say the hearing officer finds for you and they say, okay, I'm ordering you, school district, to give 2 years of dyslexia instruction. And if it's a negative appeal, I mean, if it's a negative decision, then you can appeal to district court, and you definitely need an attorney for that. Advocates can't do that. And that would go to district court. Now, if you win, your attorney can get their fees paid, but they do have to go to civil court to make that claim. So that's kind of tricky, and it can take a long time for them to get their fees paid. Now, if they don't win, they don't get their fees paid at all, and that's the same for advocates. If advocates win, they don't get their fees paid because they're not attorneys. So there's no provision there. The only thing about due process complaints, if you go with an advocate, is it's going to be a lot cheaper if you lose. So there's some factors to weigh up there. So time for questions. I see, Priscilla, you want to know what the link is. I should have your email address. And I'm wondering if it's going to be on the recording, because you're going to get the recording as well after the webinar. So how can you use this information? Well, you can use this information to talk to your spouse about, to make decisions. For example, if you are in a relationship with mom or dad or whomever, your significant other, and you're thinking about due process, you can ask yourself, do I want to spend money on this process? Do I want to try and supplement? Do I want to try another method? Do I want to move to a different school district? Do I want to put my child in private school? And I covered that in a previous webinar. These are things that you have to weigh up. But if you know all the ins and outs, it puts you in a lot better position. So I hope this has unraveled some of the legalese that's in the Notice of Procedural Safeguards. It's taken me 4 hours to get to today. But I think if you know what's in here, a lot of the times you can get more status in your odd meeting. and certainly more respect if you actually have the book, you have it in front of you, and you can literally hold it up and say, look, it's written right here, so I don't know what you mean by that. So this is how you can get in touch with me. And if that link is not still on the recording, you can reach me at info@lumenadvocacy.com. I also post the links on my Facebook business page, Makes Bed Better, so you can get it there. But I hope to do more webinars, and let me know what kind of topics you would like covered. If there's something that is really bugging you right now, some of the things that I'm seeing are new child find issues, where they're saying if you don't agree with the IEP and the FIE, your child doesn't get an IEP, which is nonsense. It's just something that they made up, and they hope they can get away with it. But yeah, let me know. I'm so glad that you attended today, and I hope you got something out of this. And that's everything for today. Thanks for attending.